welcome to our seminar on student protest encampments and balancing rights. There are a few housekeeping points that I need to make before I move on to introduce our speakers. The session consists of presentations by Henry Mahalski and Kate Allan, which will take about 20 to 25 minutes. There's then the opportunity for questions. To submit a question, which you can do at any time, we ask you to please use the Q&A button, which you should find somewhere on screen, probably towards the bottom. There might be a menu that pops up if you float your mouse towards the bottom of the screen. And a word on that, you'll only see your question, but we can see all the questions that are submitted. Unless you're especially keen to be identified as the person posing the question, then we won't identify who is asking it. For those who, unlike me, have not paid attention to their hair and makeup this morning, then you can be assured your face does not appear on the screen, only the speakers and our slides do. And as I hope a strange disembodied voice said as you joined the presentation, it's being recorded today. So allow me to introduce myself and our speakers. My name is Richard Sykes, and I'm a partner at Mills and Reeve, and I like to say that I specialise in the things that are peculiar to education. And it's my pleasure to be chairing today, and I'm going to introduce Kate and Henry to you. So Henry, from whom you'll hear first, is a principal associate in our real estate disputes team, and this means that he advises on disputes and conducts litigation where the subject matter is land. Over the late spring and early summer this year, he spent a lot of time with higher education providers as they sought advice on their options around dealing with protests. Kate, who will speak after Henry, is a principal associate working with me in our education team. As well as dealing with those university peculiar things, students, research, governance, she has the added benefit of having been at the, I suppose it's the bookshelf face, as a university solicitor at Kingston University for over 10 years, although she's been with Mills and Reeve for 7 years today. So happy M&R Day to you, Kate. We picked this topic because we feel that there are some lessons that can be learned from how institutions dealt with the various protest encampments that sprung up on many sites in the UK, including several university campuses last term. We had an occasion where the university executive had been tolerant of the protest as it was not causing any great harm or trouble, but then realised that the protest was right beside where graduation ceremonies were going to take place and got in touch with us on a Thursday afternoon asking what could be done by Saturday. Henry, seems like a perfect question for you.
Yeah, thanks very much, Richard. So during this talk, I'm going to go into quite a bit of detail in terms of what we'd need from the university to put into witness statements to really support the possession proceedings. But to start things, I thought I'd go back to basics and explain what boxes the court is looking to be ticked so that it can make an order for possession against protesters. So what is the test for showing that a claimant university can apply for possession against student protesters? If we go to the next slide, I think. And the answer to this is found in Part 55 of Civil Procedure Rules. This makes provision for the recovery of possession of land, and this includes claims under the trespasser procedure where the claim is a claim for the recovery of land where the claimant alleges is occupied only by a person or persons who entered or remained on the land without the consent of a person entitled to possession of that land. The elements relating to tenancies in the quote won't be relevant to protesters. In the context of protesters, the key points to obtain possession, therefore, is the land occupied by persons who entered or remained on the land without consent? And two, is the claimant, the university, who does not consent to their occupation, entitled to possession of that land? So the university must show that the university is entitled to possession of the land, i.e. that it has an immediately superior interest to the property. That interest could be a freehold interest if there are no subleases in place, or it could be a leasehold interest to which there are no subleases below it. If the university is entitled to possession, then it has to show that the students are not in occupation under a subsisting license. A license to occupy is at its most simple the right granted to do something which is otherwise unlawful. The right to go on to the next slide. So for the possession proceedings, what we're looking for is a summary order for possession. That is to say, an order made at a hearing without the need for a full contested trial, which could take a significantly long time. And a summary possession proceedings will be made if the court's persuaded that there is no real prospect of successfully defending the claim and there's no other compelling reason why the claim should be disposed of at trial. Key to being able to obtain possession is therefore showing that these 2 points we discussed, that the university has a right to possession and that they have no license to occupy have been clearly met by the university. The university must also show that any defence based on human rights by establishing discrimination have no real prospects of success. So you'll hear back from me shortly, but Kate is now going to discuss the various rights which need to be balanced when considering the extent of the student licence.
Thanks, Henry. So Henry's just explained that for him to be able to assist, an institution needs to be clear on the extent of the student licence to be on the premises. And you also need to be able to show that in reaching your decision to take any legal action that you've balanced various rights. So first of all, looking at students and whether they have a licence to use university land, and if so, on what terms do they have that license? Well, before the proceedings can be instigated, any license must be terminated. If a court decides that students don't enter encampments as trespassers, then they may have an arguable case for a subsisting license to remain at the protest sites, provided the protest remains within the terms of the express or implied license. So what should you do? Well, the first thing to do is look at your student contract to see what, if anything, it says about students' rights to access premises, and also look at your freedom of speech code. And you'll see from this first slide that in a recent case involving Queen Mary, the judge there took a very sensible view on there being a licence covering student access for, as they put it, the normal course of their education and student life. And the judge then went on to look at the freedom of speech code in that case and concluded that in the case of events, the general licence was subject to the terms of the university's Code of Practice on Free Speech. This is an important document in the context of the case. Essentially, it required the university's permission for the use of university's premises for an event. The encampment and its associated rallies and protests on the campus were events within the meaning of the code. The protesters did not have the university's permission to hold the encampment or their protests on its campus, and accordingly, the general licence to be on the campus did not extend to their being on the campus for the purposes of the encampment or of the associated rallies or protests. It follows that when the students were on the campus for the purpose of the protest, they were trespassers, and the university was entitled to possession as against them. So for that reason, you should certainly, in these instances, look at your student contract and your freedom of speech code. As in so many regulatory areas that we look at involving students, this is all about balancing rights, and these include the rights of the institution to its land, the rights of students to protest, and the rights of others to feel safe when accessing the university. But whatever decision you make at any point, it's helpful to be able to document and evidence your decision-making process and demonstrate both sides of all of these various arguments have been considered. And there are a number of factors here to consider. And firstly, there's the Human Rights Act. This incorporates the European Convention on Human Rights into UK law. Now, it's often said that universities are public bodies for the purposes of the Human Rights Act, but no authority is given for that assertion. And at Mills and Reeve, we take the view that while for some purposes a university is a public body, by no means can it be said that the Human Rights Act is of direct application, as it would be, say, of the government. This is relevant because it's the ECHR that protects freedom of expression in Article 10 and freedom of association in Article 11, and we'll look a bit more at those in a moment. So whether a university is a public authority and directly bound by Articles 10 and 11 is debatable, but still institutions are well advised to factor in these rights into their internal decision-making considerations and avoid unlawfully restricting them. Firstly, that's because if you do take steps to remove protesters, it's very likely that any criticism of the university is going to refer to these rights. So useful to obviously have considered them. And secondly, and I'm just going to move on to the slide here with the which has a quote from the Birmingham case. You'll see there that the judge didn't need to decide in his mind in this case whether the university was or wasn't a public authority. He simply assumed for the purposes of this particular hearing that it was, and that is the sort of standard approach at these early stages. There's no need to go into the details. The judge will likely assume So you, as the institution, will want to be able to show that you are satisfied that your decisions have been made in a manner that demonstrates that these rights have been considered. But that should, of course, be done without conceding that the ECHR is of direct effect. So what is freedom of expression? The right is a right to hold opinions and to receive and impart information and ideas without interference by a public authority. And what is freedom of assembly and association? Well, everybody has the right to freedom of peaceful assembly and to freedom of association with others. However, important to note, these are qualified rights, so they can be restricted where prescribed by law, where necessary in a democratic society in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health and morals, or the protection of rights and freedoms of others. So they're not absolute rights, they are qualified, but if you are seeking to restrict them, you need to only take actions that are the minimum necessary to achieve the aim. So take proportionate action. As an institution, you also need to factor in freedom of speech. And as you will all know, no doubt, we no longer have the Freedom of Speech Act 2023 coming into force at the moment. It may not ever come in, we just don't know. But we do still have to factor in the protections under the Education Act 1986, which, amongst other things, obliges the governing body to take such steps as are reasonably practicable to ensure that freedom of speech within the law is secured for members, students, employees, and visiting speakers. And that includes that the university needs to, as far as reasonably practicable, ensure that its premises is not denied to individuals or bodies of persons on grounds connected with their lawful beliefs or views. And it also obliges them to maintain a code of practice on free speech. So again, we come back to checking, what does your code of practice say? Making sure that it is consistent with the Education Act and using that code to let the people in the camp know how they are entitled to protest and be heard. And it's also worth noting, of course, that the OFS embeds further freedom of speech within its ongoing conditions of registration E1 and E2, and underpins these with Principle 7, which says the governing body must take such steps as are reasonably practicable to ensure that freedom of speech within the law is secured within the provider. Further duties you'll need to consider when making your decisions are under the Equality Act 2010. We've got the public sector equality duty you'll all be familiar with, but given the particular sensitivities around a lot of the issues being protested, you should ensure that you have shown considerations been given to the public sector equality duty. It doesn't direct how you should or shouldn't behave as a university, but it does direct what you should consider when making decisions. So you need to turn your mind to whether or not the decision has an impact on Equality Act matters. And if it does, you need to consider the need to eliminate unlawful discrimination, promote equality of opportunity, and to foster good relations when you're deciding what actions to take. You should also have in mind harassment, which is prohibited under the Equality Act and other legislation. We also have the OFS Statement of Expectations and now ongoing condition of registration E6. The harassment might be relevant here in lots of ways. The action taken by the students who are protesting, by the university in dealing with those students, or by other students who don't agree with the views of those who are staging the protest. So in all of this is a balancing act as ever. And when you consider the balance between all of these rights and your rights to your private land, you should look at all of the circumstances, including all that we've just talked about. So university regulations, codes, policies, student contracts, relevant legal frameworks. There are also lots of other factors which can be relevant, not least the target of the protest. If the protest is against particular university policy, it's more likely to be reasonable on university land than, say, a protest against government policy in general. So just quickly before I hand back to Henry, a couple of other issues to bear in mind. One is make sure your decision has been made by the right body at the right level. So in public law terms, make sure that you can show that the right personal committee has taken the decision, that the reporting that's necessary is in hand. Have you looked at your delegation framework? Have you looked at your, again, code of practice on freedom of speech? Another thing just quickly to think about is there anything here that might fall into being a reportable event, whether that might be the encampment itself, the decisions you take, the actions taken to address the encampment, and so on. And as ever, being mindful of all of your policies, so particular student policies, student code of conduct, disciplinary code, EDI policies, prevention of bullying, harassment, sexual misconduct, etc. So all in all, you need to balance all of these things very carefully and evidence that you've done so when making your decision with regard to any action that might be taken, and also review those as you go along. You may at one point decide you're not taking action right now, document that and move on. Why are you taking action at a later point? And I'm going to now hand back to Henry, who's going to talk about how these various rights come into play in practice.
Yeah, thanks, Kate. So this next bit is really saying what Kate's has been discussing there. How does it really lead into possession proceedings? How do you demonstrate to the court that there's no real prospect of successfully defending the possession claim and then not avoid the need for that full trial? And the answer is in evidence in the form of the witness statements provided at the hearing, showing that the factors that Kate's been discussing are enshrined into the university's decision-making process. So I'm going to talk through in quite a bit of detail what we might want to include in a witness statement. And as will become apparent, many of these things need to be thought about at an early stage and often before the protest has even commenced. So preparation is therefore key. We'd like to go to the next slide. So firstly, we will consider and reference within the witness statement the main documents that make up the student license with the university. Each university will be different, but they can include the documents shown on this slide, some of which Kate referenced. Provided a student is in compliance with the terms of the license made up by some or all of these documents, then they will be permitted access to the university property. Key, therefore, is showing that the acts of the student protesters in their particular situation exceed these rights. So the witness statement should confirm the process provided to students to allow them to organise events allowing free speech. And this links to the duties Kate discussed, for example, under the Education Act 86 to promote free speech. Consider including details of how many events have been organised in previous years and whether any have been turned down. If an event is considered particularly controversial, has the university sought to allow the event in any event by taking reasonable steps to mitigate risks, e.g. by ensuring only students with ID cards can attend, agreeing additional security measures, ensuring a neutral chair has conducted the event, or perhaps suggesting alternative venues which may be better monitored or less likely to become disruptive. If the particular protest that we're concerned about has not followed the formal guidance for organising an event, then this should be made clear within the witness statement. All right, to go on to the next slide. So this section, identifying the reasons for bringing proceedings, is really about showing to the court that the reason for bringing possession proceedings has nothing to do with, one, the university acting in a discriminatory manner in respect of any protected characteristics, and two, demonstrating that the balance of ensuring students can articulate their convention rights to freedom of expression and assembly has tipped firmly in the university's favour in protecting its right to land. In the University of Birmingham case, for example, the judge explained that in order to show the interference is necessary for the protection of the university's property rights, the decision to obtain possession must be, one, prescribed by law, and it's enshrined within the CPR 55, and also be proportionate. To show that the decision was proportionate, the judge confirmed that it's necessary to show, firstly, that the aim of obtaining possession was sufficiently important. And here the court was satisfied that the law gives strong protection to the right of a landowner to possess its own private land, and the aim was therefore sufficiently important, the aim being to obtain possession. Secondly, there is a rational connection between taking possession proceedings and the objective of obtaining possession, which on the face of it will be satisfied. Possession proceedings are obviously linked to obtaining possession. Thirdly, that other less intrusive methods are not possible which could achieve the same outcome of obtaining possession. The judge considered injunctive relief and self-help and considered that both would be equally or more intrusive remedies. Self-help, i.e. getting security to move them along without a court order, in particular, is discounted on the basis that the court process reduced the risk of the potential use of force, which could occur under the self-help abatement process. Finally, the judge was satisfied that university exercising its right to private land by taking possession of its own land comfortably outweighed, by some considerable margin, the judge's words, any rights of expression and assembly of the students in cases where, one, the university had a prescribed method of allowing free speech and assembly, i.e. by engaging with the university's process of organising events, and this had been ignored by the students. And two, given the great weight given to a landowner's right to possession of its own private land. So in most student protest cases, there should be little trouble in satisfying the court that any convention rights, if they are engaged, are not a defence to possession proceedings, where the university has provided students a means of encouraging freedom of expression and assembly by agreed procedures or pre-authorising events. We go to the next slide. So the key issue then is to provide evidence to demonstrate that the reason for seeking possession is because of the disruption that the protest is causing to the university and not motivated by any reason linked to, say, a protected characteristic. Legitimate reasons for seeking possession might include the additional security costs, which would not otherwise have been incurred but for this protest. And importantly, as far as possible, those should be quantified. Have complaints been raised by other students or members of the public in relation to the protest, and do these include evidence of perhaps unsavoury behaviour by splinter elements of the protesters? Is the protest in a particularly sensitive area or important part of the communal space of the university, which is now being dominated by one section of the university at the expense of others? Often, the decision to bring possessions proceedings might be delayed, as Richard referenced right at the beginning of this talk. And if there is a delay, then this should be explained. Often it will be because of a number of complaints has increased or because a sensitive event is on the horizon, such as exams, graduation, or open days. So all this should be included within the witness statement. Possession proceedings aren't the only means of achieving university's objective of minimising disruption to the university's business. Evidence can be provided in the witness statement to show that attempts were made to recognise the students' rights, but these have failed. That's the right to expression and assembly. Examples might include looking to engage with the students as far as possible and asking them to limit protests to set hours or set areas. When I say engage, I don't think that really means engage with their actual protest, but more their right to protest. Evidence that the students have ignored these requests can help that show that possession proceedings were therefore a proportionate response. So as Kate mentioned, it's important that evidence is provided to the court of the decision-making process made by the university. And this will be just done by showing that the university followed its internal procedures for making the decision to obtain possession, in this case, as it would in any other case, that it did not treat the decision as a tick box exercise, and that real thought went into balancing the rights of the students as against the right of the university to possession of its own property. Minutes of the decisions made by the council should be recorded and should be included within the witness statement. So I'm going to do, if you go into the next slide, if that's okay. So quite quickly, I'm going to go through the process of obtaining possession. So once the decision has been made to obtain a possession order, the notice should be given to the protesters that they are in excess of any licence to occupy, and the decision has therefore been made to seek a possession order. Often the notice is going to provide the students with a reasonable period of time to vacate prior to possession proceedings being issued. I don't think there's really generally a legal requirement to do so, but often it makes sense just practically to provide, say, 24 hours to allow some time to leave if that's what they want to do, and also for the university to get its ducks in a row in terms of getting the witness evidence put together. The claims then issued against the protest with a fairly standard particulars of claim covering the identity of the land to which the claim relates, confirming it's not residential property, confirming the university's interest, that's that freehold or leasehold, does it have that right to possession, and details of the basis on which the land was occupied without consent. Details of it is understood to be an occupation of the property, which will be students, persons unknown. In theory, you can include a claim for damages within the particulars, though in practice, this is rarely appropriate in the context of proceedings against students. The documents are then going to be issued with the court, which will fix a date for the hearing. Documents must then be served on the protesters. As the claim will largely be against persons unknown, the proceedings must be placed in, or ideally in, transparent envelopes and addressed to the occupiers and left in prominent positions around the relevant land. Unless there's reason to justify an application for a reduced service period, the proceedings must be served 2 clear days before the hearing date. At the hearing, it's essential that the person who provided the witness statement attends the hearing. If they fail to do so and any relevant area of the statement is challenged by the protesters, then the hearing is likely to be adjourned, which is obviously going to cause delay and additional cost. If a possession order is made, then it's often sufficient to cause the protesters to disband, or that seems to be the case. If they don't, however, then it's possible to apply for a writ of possession against occupiers and then enforce that via high court enforcement officers, which can be done fairly quickly. So during this talk, I'll focus on what needs to be within the witness statement. But I hope that's a helpful summary of some of the takeaway learning lessons from the recent protest cases we've obviously seen over this last year. And that's everything.
Thank you both. There is just about time to deal with one question, which I'm going to suggest is this one. How can a university deal with protesters who return, or perhaps a fresh protest that pops up in a similar or same place?
Yeah, so I think where an order is enforced but the protests return, it's generally possible to apply for a writ of restitution to enforce the original order again without the need to bring fresh proceedings. You do need to make an application if you're going to do that. And one of the key issues is going to be showing that there's a sufficient nexus between the original protesters and the old protesters. So they don't have to be the same individuals, and you're often not going to know that because they're going to be persons unknown, and you're not going to by any means have an idea of who exactly was there. But in order to use a writ of restitution, I certainly would expect them to be at least the same, ideally the same group, or certainly protesting the same issue. I think if you might come into difficulty if it was, where you would come into difficulty if it's a completely separate group of protesters protesting something completely different, in which case you're going to have to treat it as a new application, new possession proceedings.
And that is our time. Thank you very much. I'll thank you too. Start off with Kate and Henry for going so clearly through the various issues that are there to be balanced. I thank everybody for attending, and if you would like to get in touch, please don't hesitate to use the details that are currently on the screen.